My name is Adaze Okonkwo Merritt. I am 43 years old. On a Tuesday morning in February, 2 years ago, I sat at the witness table in courtroom 7 of the Fulton County Family Court in Atlanta, Georgia, across from the attorney representing my late husband's parents, Reginald and Constance Merritt, and I listened to that attorney, a man named Harold Stokes, who had been practicing family law in Atlanta for 22 years, tell the judge that I was an unsuitable primary custodian for my daughter Amara because I lacked the stability, the support network, and the specific parenting judgment that a child of 9 deserved. Harold Stokes was 61 years old, and he spoke with the particular authority of someone who had said similar things in similar rooms many times, and who had learned that saying them with sufficient confidence produced a specific effect in certain judges at certain moments. I listened to everything he said. Then I was asked to testify. What I said in that courtroom over the following 47 minutes is the center of this story, and I will tell you what I said, but first I need to take you back to the beginning, because the beginning is where the specific thing I said came from, and the beginning is where I first understood what kind of family I had married into and what it was eventually going to require of me. Let me start 4 years before the courtroom, in the specific ordinary Tuesday morning when everything changed. My husband Marcus Merritt died on a Thursday in October 4 years ago, at 41 years old, from a cardiac arrhythmia that he had not known he had and that gave no warning and no time. He was at work, at the architectural firm where he had spent 12 years building the specific professional reputation of someone who was genuinely talented and who had been consistently willing to do the work that talent alone does not do. He died at his desk. By the time the paramedics arrived, there was nothing to be done. I was at my office at Georgia State University, where I had been for 7 years as an associate professor in the School of Social Work, when my phone rang and a voice told me that my husband had been taken to Grady Memorial and that I should come immediately. I drove to Grady in the specific automated way of someone whose body is operating without conscious direction because the conscious mind has not yet processed what the information it received means. He was gone before I got there. I want to say something about Marcus before I say anything about what happened after he died, because he deserves to be known as himself before the events that followed his death define how he is encountered in this story. He was a gentleman, not passive or weak. Gentle in the specific way of someone who has decided that the world will benefit from gentleness and who practices it with intention rather than by default. He was the kind of father who remembered the specific things his daughter told him and asked about them later, not as a parenting technique, but because he was genuinely interested. He built things with Amara on weekends. Not elaborate things, but the specific small constructions of a father and a daughter who enjoy the particular satisfaction of making something from materials that were not anything before, and that are something now. He was also a man who loved his parents, and who understood their limitations with the specific patient clarity of someone who has spent a lifetime in close proximity to people whose love is real, and whose expression of that love is sometimes unhelpful. He did not defend them when they were wrong. He also did not catastrophize them. He held them with the particular patient love that was characteristic of how he held most difficult things. His parents, Reginald and Constance Merritt, had come from Jamaica to Atlanta in 1978, the specific immigrant generation of the late 1970s, whose members built their American lives through the combination of professional ambition and sustained community that characterized that wave of Caribbean immigration to the American South. Reginald had become a dentist. Constance had spent her career in hospital administration. They had built a specific and substantial life in Atlanta, raised Marcus and his sister Diane in the Cascade Heights neighborhood, and maintained across 40 years the particular standing of a family that was both professionally accomplished and deeply embedded in the specific social fabric of Black Atlanta's professional community. They were not unkind people. I want to say this clearly because the story I'm about to tell could be misread as a story about unkind people, and it is not. They were people whose love for their son was real, and whose grief at his loss was the genuine, unmanaged grief of parents who have buried a child, the particular devastating grief that no parent is prepared for, regardless of how they have prepared for everything else. They were also people whose specific understanding of what their granddaughter needed in the aftermath of that grief was organized around what they needed, which was proximity to Amara, the only remaining piece of their son, rather than around what Amara needed, which was her mother. They filed the custody petition 6 days after Marcus's funeral. I received the petition through my attorney, a woman named Patricia Lawrence, who had been my attorney for several years for various professional matters, and who became my family law attorney in that moment with the specific speed of someone who understands that the situation calls for immediate professional response. She called me after she reviewed the petition. She said, "Adaiz, I need you to come in today." I said, "Tell me what it says." She said, "They are seeking primary physical custody of Amara, with you receiving supervised visitation, pending a full custody evaluation." I said, "On what grounds?" She said, "On the grounds that you are an inadequate primary custodian due to the demands of your academic career, the absence of an extended family support network in Atlanta, the stress of your recent bereavement, and what they are characterizing as a history of prioritizing professional obligations over Amara's developmental needs." I was quiet for a moment. She said, "Adaizi, I need you to be honest with me about the family history before we go further." I said, "Patricia, I have a doctorate in social work with a specialization in child welfare. I spent 3 years before my academic career as a child welfare caseworker. I have published 4 peer-reviewed articles on factors affecting custody determinations in family court. I am not unfamiliar with what the petition they filed is trying to do, or with what will be required to respond to it effectively." She was quiet. She said, "I see." She said, "Then let me ask you this. Are there specific facts in the petition that are accurate, and specific facts that are not?" I said, "There are accurate facts arranged to tell an inaccurate story. That is how these petitions work when they are filed by people who have a motivated position and an attorney who knows how to construct a document." She said, "Explain that to me specifically." I said, "I have a demanding academic career." That is accurate. The demands of my career are part of how I model for my daughter what committed professional work looks like, which the research on parenting outcomes suggests is a positive developmental factor. The absence of Marcus's parents as a local support network is accurate and is the direct consequence of the petition they filed, which demonstrates its own circularity. The stress of my bereavement is accurate and is an expected human response to losing my husband 4 weeks ago. And the characterization of a history of prioritizing professional obligations over Amara's needs is a characterization of me that Marcus would have found specifically unrecognizable. She said, "Good." She said, "How do you know what will be required to respond effectively?" I said, "Because I spent 3 years writing court reports as a CPS caseworker and another 3 years at Georgia State teaching the course on expert testimony in family court proceedings. I know what a guardian ad litem looks for. I know what a custody evaluator assesses. I know how family court judges read the specific factors in Georgia family law. And I know that the petition they filed is not a strong petition. It is a grief petition from 2 people who lost their son and who have made a specific error of judgment about how to respond to that loss." Patricia said, "Can you prove the error?" I said, "Give me 6 months. I want to tell you about the specific 4 years of marriage to Marcus before the custody proceeding, because understanding what those years actually look like is necessary to understanding what I said in the courtroom and why it mattered." Marcus and I had met at a conference in 2012, the specific kind of professional conference where people who work in adjacent domains find each other across the particular organized randomness of professional gatherings. He was presenting on the design of community spaces in low-income neighborhoods. I was presenting on the social outcomes of community design interventions. Our presentations were consecutive, which meant that we were both in the room for each other's work, and the conversation we had afterward over terrible conference coffee was the particular conversation of two people who have been thinking about the same problem from different angles, and who recognize in each other the specific quality of someone who has been thinking seriously. We dated for 2 years. We married in 2015 at a ceremony in Atlanta at the specific venue his mother had attended 3 weddings at before ours, and that she selected, a fact I include because it is the particular kind of detail that is visible in retrospect as a piece of a pattern that was present from the beginning. Constance was warm to me across the dating years and across the early marriage in the specific way of a woman who had developed her warmth as a professional and social skill over decades and who deployed it consistently regardless of her actual feelings. I do not say this as a criticism. I say it as an accurate description of a quality that many highly accomplished women develop when they have navigated the specific professional and social terrain that Constance had navigated, which is the terrain of a Black woman in hospital administration in Atlanta across 40 years of that profession's particular demands. She was warm, and she was also, I understood from the beginning, with the specific professional clarity of someone trained to assess family dynamics, a woman who had organized her family around a specific hierarchy and who had specific feelings about the place I occupied in it. The specific feelings were not about race or class or education. They were about authority. Constance understood herself as the authority on what was best for her family and specifically for her son, and the arrival of a wife who had her own specific professional expertise and her own specific professional standing and her own specific views about what was good for her husband and her child was a particular challenge to that authority that Constance navigated through the particular indirect channels available to someone who does not express conflict directly. She made suggestions about Amara's school, about Amara's activities, about the specific nutrition that a developing child required, about the particular enrichment opportunities that the Atlanta area offered, and that we were and were not taking advantage of. The suggestions were delivered in the specific framing of someone sharing information rather than directing behavior, and they were consistent and sustained and organized around the particular implicit claim that Constance's judgment about what Amara needed was more reliable than mine. I received these suggestions in the specific patient way of someone who understands that the relationship requires a certain amount of this kind of management and who is willing to provide it within limits. I did not argue with Constance about child development or parenting philosophy because I understood that arguing would produce a conflict that would cost Marcus and that Marcus did not deserve to pay for. I managed the relationship with the particular quiet competence that I had developed in 11 years of navigating family systems professionally. Marcus knew this. He did not name it explicitly, but he knew it, and the knowing expressed itself in the specific private gratitude of a husband who understood that his wife was doing something difficult, and who appreciated it in the particular way that appreciation expresses itself in long marriages, which is through presence and attention and the specific quality of someone who sees you clearly. He saw me clearly. When he died, I lost the person who saw me clearly, and I simultaneously lost the specific buffer that his presence had provided between me and the full weight of his parents' particular understanding of my role in the family. The custody petition was the full weight of that understanding, expressed through the particular mechanism available to grandparents who have the resources to file legal proceedings. I want to tell you about the 6 months between receiving the petition and the custody hearing, because those 6 months are the specific period during which the case was built that eventually mattered in courtroom 7. Patricia Lawrence and I met every 2 weeks across those 6 months. I was simultaneously managing my teaching responsibilities at Georgia State, The particular ongoing responsibility of someone whose students needed their professor to be present and functional regardless of what was happening in her personal life, and preparing for the custody proceeding and raising Amara through the particular difficult year of a 9-year-old who has lost her father and who does not understand why the world suddenly feels so fragile. I want to describe what those 6 months looked like in the specific texture of a day, because I think the specificity is more honest than a summary. I woke at 5:30 most mornings. I had coffee in the kitchen while reviewing the case notes that Patricia had sent the evening before, or reviewing the specific family law research I was conducting in parallel with the legal process. At 7, I woke Amara and made breakfast and drove her to school. At 8:30, I was in my office at Georgia State, seeing students or preparing lectures or reviewing drafts of papers. At 1 or 2, I met with Patricia or with the family therapist I had retained for Amara, or with other relevant professionals. At 4, I picked up Amara. Evenings were Amara's time, the homework and the dinner and the specific quality of time that a mother who is also managing a significant legal proceeding tries to protect as the thing that cannot be eroded by everything else. I did not tell Amara about the custody proceeding in any specific way. I told her that Grandma and Grandpa Merritt were sad about Daddy, and that there were some conversations happening about how everyone was going to make sure she was taken care of. This was true. It was also the specific limited truth appropriate for a 9-year-old in a situation where the full truth was not something she needed to carry. Patricia retained a guardian ad litem, a woman named Christine Park, who had been conducting custody evaluations in Fulton County for 15 years. Christine Park evaluated Amara over 6 sessions, evaluated me over 4 sessions, and evaluated Reginald and Constance over 3 sessions. She also interviewed Amara's teacher, her pediatrician, and 3 other adults who had regular contact with Amara across the preceding 2 years. I want to be honest about the evaluation process, because honesty requires acknowledging that the evaluation was difficult. Not because I was doing anything wrong, but because being evaluated as a parent in a formal professional process is the specific experience of someone who is required to demonstrate something she has never needed to demonstrate before, the adequacy of her parenting, in a context where the demonstration itself introduces a quality of self-consciousness that is not present in normal parenting, and that the evaluation process is specifically designed to account for. Christine Park was good at her job in the specific way of someone who has been doing it for 15 years, and who has developed the particular calibrated attention that distinguishes between what parents say in evaluation contexts and what the actual evidence of their parenting shows. She saw Amara in our home 3 times. She observed me with Amara twice. She reviewed Amara's school records and her medical records, and the specific documentation of Amara's activities and relationships that Patricia had assembled. At the end of the evaluation process, Christine Park submitted her report to the court. I will not describe the full contents of the report because the report is a professional document that addresses private family matters and deserves appropriate privacy. I will tell you that the report's central finding was that Amara's primary attachment relationship was with me, that this relationship was secure and healthy by every measure Christine Park had applied, and that the specific concerns raised in the merits petition were not supported by the evidence of what Amara's daily life actually looked like. I will also tell you that the report contained a specific finding that I want to describe because it is directly relevant to what happened in courtroom 7. Christine Park wrote, "The mother demonstrates an unusual degree of facility in discussing her daughter's developmental needs in specific clinical terms, which reflects her professional background in social work and child welfare. This facility should not be misread as parenting by formula or as the application of professional knowledge in place of parental instinct. The observation of the mother and child together consistently showed a warm, attuned relationship in which the mother's professional knowledge and her natural parental responsiveness were fully integrated rather than in tension." She wrote that about me. I read that paragraph 4 times when the report was shared with me. Not because I needed external validation of my parenting, because Christine Park had seen something real and had described it accurately, and being seen accurately by someone who has the professional tools to see clearly is a specific form of recognition that matters in ways that personal affirmation does not. Let me stop here because I want to ask you something directly. Have you ever been in a situation where the specific thing that someone was using to challenge you was the specific thing you understood most completely? Where the attack was aimed at a domain where you had 12 years of professional expertise, and where defending yourself required simply using that expertise to describe reality accurately? Drop a comment and tell me where you are watching from and what time it is there. Because what happened in Courtroom 7 on a Tuesday morning in February is the specific thing I want you to understand, and I want you to have the full context before I tell you what I said. If you have not subscribed yet, please do. The custody hearing was scheduled for one day. Judge Patricia Elmore had reviewed the petition, the guardian ad litem report, and the preliminary motions, and had set aside 6 hours for the proceeding, with the expectation that the parties would present their evidence within that time. Harold Stokes presented the Merritt's case first. He called Reginald Merritt to testify. He called Constance Merritt to testify. He called a family friend who had known Marcus since childhood, and who testified about the Merritt's involvement in Amara's life. He called a child development expert he had retained, a psychologist named Dr. William Osei, who had reviewed the guardian ad litem report and who testified that in his professional opinion, the level of support available in the Merritt's home exceeded what was available in mine. I listened to all of it. I want to say this clearly because I think the listening matters. I did not interrupt. I did not react visibly to things that required reaction. I took notes in the specific organized way I take notes when I'm assessing the structure of an argument, noting the specific claims and the specific evidence offered for each claim, and the specific gaps between the evidence and the conclusion. When Harold Stokes finished presenting his case, Patricia Lawrence presented ours. She called Christine Park, who testified about the guardian ad litem evaluation and its findings. She called Amara's pediatrician, who had cared for Amara since birth, and who testified about the quality of Amara's health care and the specific evidence of attentive parenting visible in Amara's medical history. She called Amara's fourth-grade teacher, who testified about Amara's school performance and the specific quality of parental involvement she had observed. Then she called me. I want to describe what happened on the witness stand with the specific accuracy that it deserves, because what happened there is the center of this story. Harold Stokes cross-examined me before Patricia conducted her direct examination. This is not the standard order, but he had requested it, and Judge Elmore had allowed it for reasons of scheduling. He began with the specific line of argument I had anticipated, which was the demands of my academic career, and the particular question of whether my professional commitments were compatible with the level of presence that Amara needed. He said, "Dr. Okonkwo Merritt, you are an associate professor at Georgia State University." I said, "Yes." He said, "And that position involves research, teaching, and university service obligations." I said, "Yes." He said, "How many hours per week would you estimate you spend on professional activities?" I said, "The Bureau of Labor Statistics Survey of Academic Professionals at Research Universities estimates an average of 52 hours per week for faculty at my rank. My own hours vary significantly by semester and by project demands." He said, "So it's possible that in some weeks you work significantly more than 52 hours?" I said, "During the semester, during grant deadlines, during conference preparation, yes. It is also possible and frequent that I work considerably less." He said, "And during those weeks when you are working more, who cares for Amara?" I said, "The same people who care for every child whose parent works in any demanding profession. Her school, her after-school program, her scheduled activities, and when those are not sufficient, I have colleagues, friends, and a small number of paid caregivers who have relationships with Amara and who she is comfortable with." He said, "And this support network you mention, none of those people are family." I said, "My family is in Lagos, Nigeria. My husband's family is in Atlanta. My husband's family filed this petition, which is why the question of their participation in Amara's care is currently before the court rather than being the informal arrangement it was before the petition. He said, "Are you saying that this proceeding has damaged your daughter's relationship with her grandparents?" I said, "I am saying that the filing of a custody petition alleging that I am an unsuitable parent for a child I have raised for 9 years changed the nature of my relationship with the petitioners and consequently affected the arrangements that had previously existed for Amara's contact with them." He said, "Dr. Okonkwo Merritt, do you believe you are the most suitable custodian for your daughter?" I said, "Yes." He said, "And what is the basis for that belief?" I said, 9 years of parenting, a professional background in child welfare and child development, and the specific evidence of what my daughter's development looks like relative to every developmental measure that has been applied to her by the professionals who have assessed her." He said, "You mentioned your professional background. You are a social work professor." I said, "Yes." He said, "Do you believe that your professional background makes you a better parent?" I said, "I believe that my professional background gives me specific knowledge about child development and family systems that informs my parenting in the same way that a pediatrician's medical knowledge informs how they respond to their child's health needs. It is one of many factors in what I bring to parenting." He said, "But it doesn't give you advantages that other parents don't have?" I said, "It gives me specific knowledge. Whether that constitutes an advantage depends on how the knowledge is used. Professional knowledge in child development is useful in parenting when it is integrated with the specific human relationship between parent and child rather than substituted for it. In my experience and in the research literature, parents who treat their children primarily as subjects of professional assessment rather than as individuals in a relationship tend to produce worse outcomes than parents who have no professional background but strong relational attunement." He looked at me for a moment. He said, "You're very conversant with the research literature on parenting." I said, "I have published in it." He said, "You have published in the research literature on custody determinations specifically?" I said, "Yes." 4 articles in peer-reviewed journals over the past 6 years. He said, "On what topics?" I said, 2 on factors affecting guardian ad litem recommendations in contested custody cases. 1 on the relationship between parental grief response and custody outcomes following spousal death. 1 on the specific risk factors that distinguish grandparent custody petitions filed in the context of genuine child welfare concerns from those filed in the context of family conflict following parental death. The courtroom was quiet for a moment. Judge Elmore said, "Counsel, where are you taking this?" Harold Stokes said, "Your Honor, I'm establishing the witness's professional expertise in the relevant area." Judge Elmore said, "I think you've established it. Move on." He moved on. His remaining questions were less focused, the specific recalibration of someone who has encountered something he had not anticipated and who is deciding how to continue without making the situation worse than he has already made it. Patricia Lawrence conducted the direct examination. She said, "Dr. Okonkwo Merritt, you mentioned your article on grandparent custody petitions following parental death. Can you describe the research?" Harold Stokes objected. Judge Elmore overruled. I said, "The research examined 63 grandparent custody petitions filed in Georgia family courts over a 10-year period following the death of a child's parent. The study analyzed the specific stated grounds of each petition, the evidence offered in support of those grounds, the guardian ad litem recommendations in each case, and the court's eventual determination." Patricia said, "What did the research find?" I said, "The research found that grandparent custody petitions filed within 30 days of a parent's death had a specific and distinctive profile relative to petitions filed at other times. They were significantly more likely to be filed by grandparents who had experienced recent bereavement, significantly more likely to rely on the specific claim of inadequate parenting rather than documented evidence of harm, and significantly less likely to be supported by guardian ad litem recommendations than petitions filed in other contexts. I said, the study found that this specific profile was consistent with what the grief literature describes as the particular response of bereaved grandparents who experience the loss of their child as also a loss of access to their grandchild, and who sometimes translate that grief response into a legal proceeding as a mechanism for maintaining the connection that the grief is threatening. Patricia said, "Is this description applicable to the petition filed by the Merritts?" Harold Stokes objected on grounds of relevance and improper opinion testimony. Judge Elmore said, "I'll hear the answer and then rule." I said, "The petition filed by Reginald and Constance Merritt was filed 6 days after my husband's funeral. It relies on the specific claims of inadequate parenting rather than documented evidence of harm. The guardian ad litem report does not support its central contentions. These are factual characterizations, not opinions. Whether the factual pattern is consistent with the specific profile my research identified is a question that I believe the court can assess." Judge Elmore sustained the objection on the narrow question of whether the specific pattern applied to the Merritt's petition, but allowed the research testimony to stand. Patricia said, "Dr. Okonkwo Merritt, do you love your daughter?" I said yes. She said, "How does your daughter respond to you?" I said, "She climbs into my bed in the morning before I wake up because she knows I will not be annoyed. She tells me when she is worried about something before she tells her friends. She asked me last week to teach her how to make jollof rice the way my mother makes it because she said she wanted to know how to make it when she grows up. She is 9 years old and she is grieving her father, and she is doing it with the particular resilience of a child who is securely attached to her remaining parent." Patricia said, "Thank you." She sat down. Judge Elmore took a recess for 40 minutes and returned with her ruling. She denied the Merritt's petition. I want to describe the specific language she used because I think it matters. She said, "The court has reviewed the guardian ad litem report, the testimony of the various witnesses, and the specific grounds of the petition. The court finds that the petition does not establish a basis for modifying the existing parental relationship. The petitioners have demonstrated that they love their granddaughter and that their involvement in her life has been beneficial. The court finds no evidence that the child's current custodian, her mother, is in any way unsuitable, or that the child's welfare is better served by the modification sought." She said, "The court would note for the record that the petition was filed 6 days after the death of the child's father, a period that this court recognizes as a time of extraordinary difficulty for all parties. The court would further note that the specific testimony of the mother, including her professional expertise in the relevant research literature, was among the most substantively informed testimony this court has received in a custody proceeding. Whether that expertise is an advantage in parenting is a question this court does not need to resolve. It was clearly an advantage in this courtroom." She looked at both tables. She said, "The petition is denied. I would strongly encourage all parties to pursue mediated family counseling before any further legal proceedings are considered. These people all love the same child. That is worth more than any of the other things that are currently in dispute." She stood. The courtroom stood. I sat for a moment before I stood. I want to tell you about the conversation I had with Constance Merritt in the courthouse corridor after the ruling, because it is the part of this story that matters most to me and that I have thought about most often in the 2 years since. She was standing in the corridor with Reginald and Harold Stokes when I came out. Harold Stokes was speaking to them quietly. When I came through the door, Harold Stokes looked at me and then looked away. Reginald Merritt looked at me with the specific expression of someone who has been through something and who has not yet decided what to think about the outcome. Constance looked at me with a different expression. She said, "A daze." I said, "Constance." She said, "Can I speak with you?" Reginald touched her arm. She shook her head slightly. He stepped back. She said, I want to tell you something. Not as an apology, because I think apologies after something like this are a form of cheapening what happened. As an explanation. I said, all right. She said, when Marcus died, I lost the most important person in my life. I know that sounds wrong when you're standing in front of me because you lost your husband. But Marcus was my son. He was the person around whom the whole shape of my life had been organized since the day he was born. She said, when he died, the only piece of him that was left was Amara. And I was afraid that piece was going to disappear too. Not because of anything specific about you, because the specific shape of the world in which I would see Amara regularly required Marcus, and Marcus was gone. I said, I understand that. She said, I let that fear become a legal proceeding. That was wrong. Not because of the law, because of what it cost Amara. She is 9 years old, and she lost her father, and then her grandparents told a court that her mother was inadequate. Whatever that has done to her understanding of her family, that is the cost of what I did. And I am going to be living with that for a long time. I said, Constance. She looked at me. I said, Amara loves you. She loves Reginald. She asks about you. The specific thing you are afraid of losing, which is Amara's ongoing presence in your life, is not going away because of this proceeding or because of Marcus's death. It is going away only if we allow it to go away. I have not allowed it to go away, and I am not going to. She said, after what we did? I said, after what you did. Yes. Because Amara needs her grandparents, and because Marcus loved you, and because what you did came from grief, and grief is not a thing I am going to punish. She said, what do you want from me? I said, come to Amara's birthday next month. Bring the specific cake you always bring because you know it's her favorite. Be there. That's what I want. She looked at me for a long time. She said, you're a remarkable woman. I said, I'm a practical woman, and I am also Amara's mother, which means I understand that the best thing for Amara is a family that is present and functional, and I am willing to do the specific work required to make that possible, even when the work is harder than it should be. She said, Marcus was right about you. I said, what did he say? She said, he said you saw things clearly. He said it was the thing he valued most, that you saw things as they actually were without needing them to be different. I said, he was the person who saw me clearly. I miss that every day. She said nothing. Her eyes were very bright. I said, bring the cake next month. She said, I'll bring the cake. I want to tell you what the 2 years since the hearing have been, because honesty requires the full account. Constance and Reginald come to Amara's significant occasions. They come for birthday dinners and for the school performances, and for the specific small occasions that accumulate across a child's life and that constitute the actual texture of family presence. Constance brings the cake, the specific rum cake that Amara has loved since she was 3, and that Constance makes from a recipe her own mother brought from Jamaica, the particular Caribbean sweetness that Amara identified early as the smell of her grandparents' kitchen. The relationship is not what it was before the petition. I want to be honest about this because pretending it is would be its own specific form of dishonesty. There is a specific knowledge between Constance and me now that was not there before, the knowledge of what she was willing to do, and the knowledge of how I responded, and that knowledge lives in the space between us in all of our interactions. It also produces something, not entirely comfortable, honest. The specific honesty of two people who have seen each other in a context that required them to be exactly who they are, and who are now navigating a relationship with that specific visibility as the foundation. Amara asked me once, in the specific direct way she asks things she has been thinking about for a while, Why Grandma Constance and I sometimes seem careful with each other. I said, we went through something difficult together after Daddy died, and we are still learning how to be with each other afterward. That happens sometimes when people go through hard things together. She said, are you friends? I thought about Constance. I said, we are the people who both love you most. That's a specific kind of relationship. It doesn't have a normal word for it, but it matters. She said, like family. I said, exactly like family. She said, okay. She went back to whatever she had been doing. Amara is 11 now. She is, in the particular assessment of her teachers and her pediatrician and her therapist, and every adult who knows her, a child who is navigating the specific grief of losing her father with the resilience and the particular emotional vocabulary of a child who has been well supported across the 2 years since his death. She talks about Marcus. She has a photograph of him on her desk that she put there herself. She asks questions about him when the questions arrive, which they do in the specific, unpredictable way of a child's relationship to grief, at dinner or at bedtime, or occasionally on a Saturday morning while we are making breakfast together. I answer the questions with the specific honesty that she deserves, the particular honesty of someone who understands that children are capable of more truth than adults sometimes give them credit for, calibrated to what is useful to her at the age she is and where she is in her grief. She is fine. Better than fine. She is the specific, remarkable person that her father was raising her to be, and that I am continuing to raise her to be. And the particular evidence of that is not in any court document or guardian ad litem report, but in the specific, ordinary daily texture of watching her be exactly who she is. Here is what losing my husband and responding to a custody petition with 12 years of professional expertise and 1 testimony in courtroom 7 taught me. I know that the specific knowledge you build across a professional life is not only professional, it lives in you in the way that all genuine knowledge lives, which is as a framework for understanding situations that you encounter, and when you encounter a situation that your professional framework addresses directly, the knowledge is available not as an external resource you consult, but as something you already are. I did not go into courtroom 7 with a strategy organized around my professional expertise. I went in as myself, which included my professional expertise as one of the many things I am. And when Harold Stokes asked me questions about parenting and child development and custody research, I answered from what I knew, which was considerable. And what I knew was considerable because I had spent 12 years building knowledge in exactly the domain that the hearing was about. I know that grief makes people do things that are not themselves, that the specific devastation of losing a child can organize a person's behavior around the fear of losing the remaining connection to that child in ways that produce harm the grieving person did not intend and would not have chosen with full information. Constance Merritt did not file a custody petition because she wanted to harm me or Amara. She filed it because she was terrified, and grief was doing most of the work of her decision-making at the time. Understanding this did not make the petition less harmful or less difficult to respond to. It made it possible to respond to it as what it was rather than as what it might have looked like on the surface, which is a vindictive legal action from people who did not like me. It was not a vindictive legal action from people who did not like me. It was a grief response from people who loved their granddaughter and did not know what else to do with the specific shape of the fear that Marcus's death had created. And I know that the 2 things that mattered most in courtroom 7 were not my professional credentials or my published research. They were Christine Park's report, which was the specific, accurate account of what my relationship with Amara actually looked like, and the specific moment when I said that Amara climbs into my bed in the morning and tells me when she is worried and asked me to teach her to make jollof rice because she wants to know how to make it when she grows up. Those things were not professional expertise. They were the specific evidence of a mother and a daughter, particular and specific and mine, and no legal proceeding and no credential and no peer-reviewed article on custody determinations produced them. 12 years of professional knowledge informed how I presented them. They were real before I knew anything. That is my story. A custody petition filed 6 days after a funeral. 12 years of professional expertise in exactly the domain that the petition required expertise to address. 47 minutes of testimony in courtroom 7. And a rum cake that Constance Merritt brings to Amara's birthday every year, because it is the specific cake her granddaughter has loved since she was 3 years old. If this reminded you of a time when what you had built professionally and what you were personally arrived at the same place at the same moment, and of the specific quality of that convergence, I want to hear from you. Drop it in the comments. Share this with someone who needs to know that the specific knowledge you build across your professional life is never only professional. It is part of who you are, and who you are is what matters when the moment requires it. Hit subscribe, and I will see you in the next one.